hearing in the appeal of Byers and others against the Saudi National Bank. Good morning, Mr. Director.
My Lords, may it please you, I appear with my learned friend Mr. Knott for the Appellants, my learned friend Mr. Green, King's Counsel, with Mr. Roxburgh for the Respondent Bank. I think you have been provided with an agreed timetable. I'll be on my feet hopefully until 3:30 today. In terms of use of our time, we were going to offer some observations in relation to the claim of knowing receipt at a relatively general level first, and then by invitation offer some observations about unjust enrichment insofar as that is of relevance in this case, and thirdly then to go through case law in an unimaginatively chronological order, because we suspect that the Court will be assisted by seeing the way in which this particular area of the law has developed and what has been looked at and what hasn't over time. So if I could start then just by reminding you, as I'm sure you are aware, that the issue that we are dealing with is very narrowly stated, which is the question whether or not a claim in knowing receipt requires the claimant to prove that they have a continuing right of equitable ownership in the property, or an undestroyed proprietary base, as Mr. Justice Millett, as he was in the Macmillan case, put it. Whether that undestroyed proprietary base is required in addition to knowledge on the part of the defendant, such as to make it unconscionable for the receipt of the property, the benefit of the property to be retained.
And it's an equitable proprietary base?
Yes. It may help if we offer just a few remarks about terminology first, because language has been used in a number of different ways over the years, and it may just be a matter of usage over time. But first of all, I just wanted to offer some thoughts about the words constructive trust and constructive trustee. We have seen those in different cases used in relation to, for example, a fiduciary who receives a bribe or an unauthorized profit. And it is said that that bribe or unauthorized profit may be held by the fiduciary on a constructive trust for the person to whom he owes a fiduciary duty. Sometimes the language of constructive trust and constructive trustee are used in relation to someone who is a trustee de son tort, somebody who takes on themselves the position of a trustee, not in order to do wrong, but in order to administer the trust, although not formally and properly appointed to be so. Thirdly, the labels constructive trust and constructive trustee are sometimes used when referring to a person who, again, has not been formally appointed as a trustee, but to whom trust property has properly been transferred, for example, an agent, where property is transferred properly by the formally appointed trustee to somebody who hasn't been appointed as a trustee, but is aware of the trust. And in that situation, the agent may be described as a constructive trustee. There are occasions when the term is used in the particular context with which we are concerned, which is where they are used to refer to a person to whom trust property is transferred in breach of trust. And finally, it is important in our submission when looking through the case law to bear in mind that the terms constructive trust and constructive trustee are often used in relation to situations where there is no trust as such and no properly appointed trustees. For example, and we will see several of these, cases involving the misapplication of company money.
Well, the breach is a breach of fiduciary duty, but not a breach of trust.
Exactly so.
And the argument will be, no doubt, that the company has no beneficial interest after the transfer.
That will be so. But just in terms of looking at what the constituent elements of the liability in knowing receipt are, in our submission it is important to bear in mind that the existence of a trust as such is not a precondition to liability. There can be situations where transfers are made either by directors in breach of their fiduciary duties to the company, or, and we will also see a couple of examples of this, situations where public property, Crown land, is transferred and a minister or other public official who has responsibility for the stewardship of such property acts in breach of their duties under public law to administer public funds in the public interest. So the term constructive trust and constructive trustee often used, as I say, in situations that don't technically involve the existence of a trust at all. So we just wanted to sort of park early on in your Lordship's minds, if it's not already there, the thought that when we are reading the case law, we do need to be alert to exactly how the expressions are used in each particular context. And for the purposes of our submissions, in this case, we're going to try and avoid using the terms constructive trust and constructive trustee altogether and refer only to knowing receipt, because that is specifically the issue, obviously, that's before you. Having said that, it is also the case that the term knowing receipt has itself been used in slightly different contexts. It is sometimes applied to a situation where trust property, again, is transferred entirely properly without any breach of trust to a third party who has not been appointed as a trustee but knows full well that they are receiving trust property. There are occasions when it is used in that way. If they then act in a way, if they deal with the property inconsistently with the trust, they may be said to be held liable as constructive trustees at that point. But that is not what this case is about. This case, as you are well aware, is concerned with what we would suggest is the paradigm situation for knowing receipt, as described by Lord Justice Hoffman, as he was in the El Ajou case.
Just before you leave it, could you at some stage perhaps just give us an example, a case example of what you just referred to?
Certainly. We'll do that. Yes, we don't want to burden you with unnecessary lists, but we might produce a sort of table illustrating each of the usages, if that would help. Excuse me. The paradigm situation, we would suggest, is, as we say, the situation described by Lord Justice Hoffman as he was in El Ajou, where there is a transfer of property in breach of a fiduciary duty to a third-party recipient who has sufficient knowledge of the breach to render it unconscionable for them to retain the benefit of the transfer. And that is the formulation that we suggest describes knowing receipt as we will be using that term in the course of this appeal. The other term that it may be just worth...
Will you at some stage be explaining what is sufficient knowledge to make it unconscionable?
Probably not.
Because that seems an entirely circular formula to me.
Well, it's a formula that has received the blessing of the Court of Appeal in the Akindele.
Well, I'm well aware of that, which is all the more reason to hope that it might be possible to improve on it, since it
if it were in
seems to be in widespread usage.
Yes. I wasn't going to try improving on it because I think it was latched onto as a formula that was intended to allow courts to make essentially a judgment call as to whether the circumstances...
To make it up as they go along, as
No,
it were.
to apply a principle to different facts, because it is impossible, particularly in a common law jurisdiction where cases are decided by reference to the facts in front of the court in a particular trial, to lay down a sort of checklist of what renders receipt sufficiently unconscionable, or what renders the knowledge sufficiently unconscionable. There was the attempt, as you know, in the case of Baden, to sort of categorise, I think, 5 different levels of knowledge.
Well, that's going to the other extreme.
Indeed it is.
But there's a fairly basic distinction between actual knowledge and you might call constructive knowledge, or
yes.
knowledge that a reasonable person
yes.
would have, or something like that. And
yes.
that's a fairly fundamental distinction, one might think.
We will certainly seek to support the position that the law has reached so far, which is that what is required for knowing receipt is knowledge of the breach of trust. What more you need, so to speak, to describe or predetermine than that in order to reach the conclusion that retention of the benefit of the transfer is unconscionable is a matter that we would suggest is best left to the judgment of trial judges on the facts of individual cases rather than trying to prescribe. So we weren't proposing to try either reverting to Baden or improving, perish the thought, on what Lord Justice North said in Akindele.
So notwithstanding the circularity, you're saying it's a case of the court recognising it when they see it?
Yes.
Case by case?
Yes, and that's not a circular argument. It is simply a recognition of the fact that there are certain areas of the law in which judgment needs to be exercised, so long as the test of a sufficient degree of knowledge of the
When you
breach.
emphasise knowledge, do you mean actual knowledge, or are you keeping that nicely open?
Well, it is. I'm not trying to persuade you to depart from Akindele, not least because that's not the issue that's in front of you.
Yeah.
So what we certainly would suggest is that it has become clear that knowledge certainly means knowledge, not notice. And that's been clear since the Montague case.
So you're leaving open whether it's actual or constructive knowledge, because you say that's determined case by case according to an underlying concept of unconscionability.
Well, it isn't one of the issues in this case.
No.
So it's not something on which we were proposing to take a position. There is an observation from Lord Gough in the West Deutsche case about the risks when an interesting issue comes before the highest tribunal in the land. The risks in being seduced into trying to sort of, in a sense, codify a whole area of the law. Lord Gough does observe, and with respect, in a common law jurisdiction, rightly so, the importance of deciding the issue that is in front of the court, rather than expanding upon issues that are not necessary for the decision in the case. And
Well, you have baked it into your issue, this formula.
I'm sorry?
You have baked it into your formulation of the issue.
Well, the circumstances of this case are such that it is not open to the respondents because they failed to comply with their disclosure obligations. They were debarred from defending certain issues. And so the Statement of Facts and Issues recites that it is common ground that they do have sufficient knowledge to render it unconscionable.
But we don't know on these facts what that actually amount to. Is that right? We don't know whether that's actual or constructive knowledge.
For the purposes of this appeal, you don't need to know that, and that's why it's not in the Statement of Facts and Issues.
Yeah, so you're warning us against excessive obiter dicta. Thank you.
A warning would be a very presumptuous thing to do, but I would be urging your lordships to focus on the issue. The other term that we were just going to offer some thoughts about is the word tracing, which obviously comes up in quite a lot of the cases. The word tracing in many people's minds tends to conjure the idea of a proprietary remedy. But we will suggest as we go through the case law that it is important to bear in mind, and this is the way, again, Mr. Justice, Lord Justice, or Lord Millett, depending on which status he was in at any given moment, reminds us that tracing is a process. It's not a cause of action, and it's not a remedy. It is a process. And it is a process which may be relevant either in the context of a genuinely proprietary claim, or we would submit in the context of a purely personal claim. It will be relevant in a proprietary claim because if a claimant is saying that asset in equity belongs to me because it was bought with proceeds that came out of an account which I was beneficially entitled to, there is essentially the evidential process of tracing to work out whether that asset does indeed represent the proceeds of funds that belonged in equity to the claimant in the first place. But we will submit that the process of tracing can equally be relevant in relation to a personal claim where the claimant is seeking to fix a recipient with personal liability to account in respect of property which has been transferred, as we will see from the case law is one of the requirements, which has been transferred as a direct consequence of a breach of fiduciary duty. In order to establish the evidential basis of a claim in knowing receipt, you have to establish factually that the property received by the putative knowing recipient was transferred as a direct consequence of the breach of fiduciary duty. So the process, the evidential process of identifying where the asset currently in the hands of the alleged knowing recipient is, where it came from, that is equally well described as a process of tracing. So we would simply urge, the reason I mention this now is that we would urge on your lordships not to assume that when the case law talks about tracing, it is talking about a stage in a proprietary claim. And that rather leads one into a few remarks about the concept of a liability to account. Again, when we get to the case law, we will see reference to the person who is a knowing recipient being made personally to account as if they were a trustee. The liability to account in our submission means just that. It is an obligation on the defendant to explain what they have done with the property that they have received. I wasn't going to go to it, but there's a little bit incidentally in the bundles. As I say, I'm not going to go to it now, but there's a passage on what giving an account means in Lewin on trusts at paragraph 41.003, which is in bundle 4, tab 77. 2470. I don't ask you to go to it now, but it's bundle 4, tab 77, 2470.
Well, if everyone is I don't know, if everyone's working from electronic documents, you won't need to refer to bundles and tabs, but
just
if council are not, then if council's not working electronically, then please refer to it. Otherwise, please just give us the electronic bundle number.
I'll do that. I'm grateful. As I say, the concept of somebody being made to account it captures the idea that the defendant has to explain what they have done with property that has been received. And if the claimant in a claim for an account is dissatisfied with the way that the defendant has dealt with the property, they may, using the traditional equitable language, either surcharge or falsify the account. And the claimant will surcharge the account if he alleges that the defendant has not obtained for the benefit of the fund all that they might have obtained if they had used due care and diligence. And if the surcharge is proved, then the account is taken as if the defendant had received for the benefit of the fund what they would have received if they had used due care and diligence, which is what personal liability means, making good to the fund what would have been there if due care and diligence had been applied. And conversely, if a claimant falsifies the account, what they are doing is alleging that the defendant has applied the property in a way that they should not have done, by making an unauthorised investment or paying out the fund to someone who is not entitled. And if that allegation, if the allegation of falsifying the account is made out, then again, the defendant has to make good what should have been in the fund from their own resources. That is what personal liability means. So in both surcharge and falsifying cases, the defendant will be required to make good from their own resources what should have been in the fund. And that, we submit, is quintessentially what personal liability is. And the liability to account, as if you were a trustee, is the liability that is visited on a knowing recipient. And in our submission, it differs fundamentally from the claim that is made in a proprietary case. A proprietary case is, give that back, it's mine. You've got my briefcase, you've got my funds, whatever it is, give it back. A liability to account is a personal requirement to explain what you have done with property that has been received, and to make good if the property that you now hold isn't what it should be. So we would submit that the fundamental difference between a proprietary claim and a claim to an account is that a claim to an account is something, in one sense, more than a proprietary claim, but it's not more in the sense that it is a proprietary claim with something extra. It is of a different quality. A claim for an account, as we say, is the obligation to explain what has been done with the funds and to make good if what has been done with them is what should not have been done. The claim...
Are they on your submission tied together to the extent that if the defendant, who is the knowing recipient, still has the property, there would be an equitable proprietary claim stroke remedy?
They're not tied together in the sense that they are in no sense mutually dependent. Factually, they may coincide. And that, I was going to come on to that, and I'm grateful your Lordship raised it. I was going to come on to that in a moment or two. But it is the case, and this again in our submission is why there may have been some confusion in the case law or in some commentary on the case law. Because it is often the case that a proprietary claim is brought against somebody who happens to be a knowing recipient. That doesn't make the proprietary claim the claim in knowing receipt. The claim in knowing receipt is a claim that is brought on the basis of the trio of considerations that, as I say, we see from Lord Justice Hoffman in Elaju, of a transfer and breach of fiduciary duty, direct consequence of that being a receipt, with sufficient knowledge on the part of the recipient to make it unconscionable for them to retain the benefit of the transfer. Those are the constituent elements to make somebody personally liable to account as a knowing recipient. A proprietary claim requires you to identify property that in equity belongs to you in the defendant's hands, and it may well be, as I say, that a proprietary claim can be brought against somebody who happens to be a knowing recipient. But conceptually, we would submit that they are separate claims, and the fact that in certain factual situations they may both exist against the same person should not lead the court to be confused as to the substance of the remedies that are actually in play. I was going to lead up to that through just a brief reminder about the claim in this case. The claimants in this case do not and never have claimed either a declaration that what have been called the disputed securities, as they are termed in the pleadings, the claimants have never said that the disputed securities belong to Sard Investments Company Limited, SICL, and the claimants have never sought an order requiring Samba, the original recipient, or the Saudi National Bank, to transfer the disputed securities to the claimants. It's not a proprietary claim. We're not saying the shares are ours, give them back. The claim is a claim in knowing receipt addressed to Samba, originally, now SNB, saying that they should account. Tell us what you have done with the benefit of that transfer.
And does the obligation to explain, does that extend to property that is one's own property?
Well, you've beaten me to my next point but one. What we were going to say, just based on the nature of the claim that has been made in this case, is two things. The first is that the claim we are advancing does not involve any interference with the property law of any other jurisdiction. We are not saying English law says that the shares belong to SICL. That would be a proprietary claim. It's not our claim. We are not seeking to interfere or overturn the laws of property of Saudi Arabia. There's quite a long section in Milano Friend's written case, paragraphs 39 to 49, where he seeks to persuade you that if you allowed this appeal, it would involve an interference with the property law of other jurisdictions. It wouldn't, because we are making a personal claim to account. We're not saying the shares belong to us. We're saying to Saudi National Bank, tell us what you've done.
Could you make a claim in this scenario that the shares belong to you?
It's not something.
What I mean by that is, we know that under the relevant property law that is being applied to the transfer, there is an extinguishment of title. That is the original title. So an unencumbered title goes to the recipient.
Yeah.
Would you accept that kills off any possible equitable proprietary remedy?
Lord, I don't know whether my clients need to commit to an answer to that, because it isn't one of the issues that's in front of the court. If my clients had brought a proprietary claim, I think I, as a mere advocate, would have to recognise that they would be facing some difficult propositions in the case law about the property in relation to an asset, the ownership of property in an asset being a matter for the law of the jurisdiction where the asset is.
Yeah.
So there certainly is some case law that would make the argument difficult. I don't know that I need to commit to saying, yes, we would lose.
But in a way, that's why your claim is formulated as a personal claim. And
it probably is.
And you say it doesn't matter.
That probably, I'm obviously not the draftsman, that is no doubt a part of the thought process.
But it is important, I think, for us in getting the overall picture, because I think it's likely to be said against you that although you are drawing a clear and sharp distinction between a personal remedy and a proprietary remedy, it might be said against you that the two are linked, in the sense that if the knowing recipient still has the property, there must be, on this hypothesis, a proprietary claim in order for there to be a knowing receipt claim. So it is important, I think, for us to know what your submission is as to whether the extinguishment of the title, as it would appear to do, would knock out an equitable proprietary claim.
My Lord, it is, as my Lord Legate mentioned a moment ago, it is the fact that we have only made a personal claim, and it is a fact that the issue in front of the court is whether that personal claim can survive, notwithstanding the extinguishment on the facts of this case of any equitable ownership in the shares. As I say, your Lordship used the word linked in the way your Lordship put the question. As I say, we would submit that the question whether a proprietary entitlement is a necessary ingredient of the claim in knowing receipt is the issue between my learned friend and I in this appeal. I'm
just trying to pinpoint how far you are different, because it might be said, well, all the parties are agreeing that if the property was still there, there would still be a problem with an equitable proprietary claim because title has passed.
I don't think I could be contradicted by accepting that there would be a problem. I don't think I need to commit as to whether it would be inconceivable. As I say, it's not a point in the... I'm not trying to sort of avoid the issue. I'm simply trying to point out what is...
You would have an uphill struggle, should we say?
I would definitely be working hard. The second point we just wanted to make, so the context from which that flowed was our observation that the claim in this case is only a personal claim and not a proprietary claim. So, and the first sort of consequence of that, as I say, is that we are not seeking an outcome that would interfere with the property law of any other jurisdiction.
Well, except that you're asking the defendant to account, i.e., tell you what he's done with property which he says it's mine.
Well, that's exactly my next point. Exactly. If a person who has received property, knowing it's transferred to him as a direct consequence of a breach of trust, and the court says, you are liable to account, tell us what you've done with it.
He says it's mine.
His answer is, well, I have dealt with it in such a way that as a matter of property law, it doesn't belong to you anymore. Now, in our submission, in the context of a personal claim to an account, that's not a defence, because the constituent elements of the claim in knowing receipt are a transfer in breach of fiduciary duty, the transfer the transfer to the allegedly knowing recipient being a direct consequence of that breach of fiduciary duty, and it being unconscionable that the recipient should retain the benefit of the transfer. In our submission, it is no answer. If that trio of elements gives rise to a personal liability to an account, it is no more an answer to the requirement to give an account to say, well, I've dealt with it in a way that destroys your equitable ownership, than it would be to say, I've dealt with it in a way that destroys the property. I've blown up the house. I've burnt the painting. If the answer to the claim for an account is that the recipient has destroyed that which has been transferred, I
don't think that is the answer, is it? It's the answer is that I never got your property.
It's mine.
When it reached me, it was my property. It's not anything I did that's made it cease to be your property. It's the fact, in my hands, it never was your property at all.
It is the process. In a sense, what we may be doing is redescribing the issue between the parties, which is, is it a necessary element in the claim for knowing receipt that the property should remain beneficially owned by the well, not by the transferor, but beneficially owned by the claimant.
Yes.
And
it is an answer. Do you accept that it's an answer to a claim in knowing receipt? Say, yes, I have I knew before I disposed of the property that it had been transferred to me in breach of trust, but at the time it was transferred to me, I didn't know, And what's more, I was equity's darling. I mean, do you accept that once you're equity's darling, that closes off any subsequent claim in knowing receipt, even if you later find out that it was transferred to you in breach of trust?
Well, again, Lord, that isn't an issue that needs to be decided in this case, and the answer may well be no, it may not be an answer, depending on the facts. You can't, with respect, say prospectively that in that situation it will necessarily always be conscionable for a person to retain the benefit. In a high proportion of cases, it may well be. Equity's darling may well provide, the fact of being equity's darling may well provide the recipient with a defence to a claim in knowing receipt, because in a high proportion of cases, the court is quite likely to reach the view that if you have paid good consideration and you didn't know at the time, it's not unconscionable to retain the benefit. But the difference between my learned friend and I in answering that question, hypothetical and not necessary for this appeal, is the basis upon which we're answering it. My learned friend says,
You say it's because it overreaches your beneficial interest.
My learned friend says that the reason equity's darling has a defence to a claim in knowing receipt is because beneficial ownership.
So I meant overrides, not overreaches.
Yes, yes. But leaving that aside, my learned friend, I think in a sense we are both relatively close as to outcome, but different as to reasons. When I say we, my learned friend and I, he will say equity's darling has a defence to knowing receipt because continuing equitable ownership is a necessary part of a knowing receipt, and that will disappear if there's a bona fide purchaser for value. We say the constituent elements of knowing receipt are the trio of factors that we've identified. It's a personal remedy, it's not a proprietary claim. It may often coexist with a proprietary claim. It may often be factually defeated in circumstances where there is a bona fide purchaser for value, because the court may well reach the view that if you are a bona fide purchaser for value without notice, that it's not unconscionable for you to retain the benefit of the transfer.
Well, I mean, either it is or it isn't. Surely you can't just decide, or you're going to tell me that this depends on, how it strikes the judge. I mean, what makes it unconscionable or not? Either the fact that you've received it without notice and for value means that it's not unconscionable, or it doesn't.
Well,
or it might not for some reason.
Equity operates against the conscience of the individual by reference to the circumstances of each case. I mean, you can't prescribe in advance the circumstances in which an interlocutory injunction may be granted. Phrases such as just...
That would imply it's completely unprincipled. I mean, surely there are more principles than that. But can I'm just confused about our example, and I think we need to get it absolutely clear. I mean, if we've got equity's darling receiving the property, there is no prospect of knowing receipt, because that person isn't a knowing recipient. So the example being put to you is the variant,
yes,
which was, I think, put forward in the respondent submissions. In fact, there are two variants. The first variant is, I'm a bona fide purchase for value without notice and receive. Then, while still having the property, I acquire knowledge. That's...
sorry, that was what I thought I was answering.
Okay. That's hypothetical one. Hypothetical two is there are two recipients. The first recipient is a bona fide purchase for value without notice, but then passes it on to recipient two, who knows that it's been transferred in breach of trust or breach of fiduciary duty. Now, the argument against you is that the extinguishment of the title because of equity's darling means that there is no possibility of any subsequent claim for knowing receipt. Now, your answer, as I understand it to that, is, oh, well, that just depends on whether it's conscionable or unconscionable. Well,
yes.
I struggle to see that is... What variant on the facts can help you to decide what makes the difference? I mean, surely it depends as a matter of principle. It can't depend on any fact. You can give me any number of facts, and it's not going to make a damn bit of difference to the answer to the question of principle, I don't think.
Well, we, albeit I think in passing, refer to Stapleford Colliery, which is a case in which the court did say that if the onward recipient themselves owed fiduciary duties in the first place, then equity would operate against that onward recipient, even though the interim recipient may have been equity's darling. So there are facts.
But the example that Lord Byers is giving you is where D2, that is the second transferee, is a stranger to the trust, not the trustee or the person with the fiduciary duty, which may come back to life if he gets the property back. He will be assumed to have got the property back in performance of his duty to not to have lost it in the first place.
Yes.
I mean, that Stapleford example seems to me a clearly understood and recognised principled answer, that if it goes back to the original trustee, we are in a different position as a matter of principle.
Yes. But what that then does is illustrate that there are facts in which an equity may regard the onward recipient as having their conscience struck by the receipt.
Mr. Crowe, we all accept, well, probably most of us accept, that the ultimate underlying purpose which equitable principles satisfy includes dealing with unconscionable conduct. But it's not an uncharted ocean. All the principles are, if you like, indices in the chart by which equity achieves that underlying purpose.
Yes.
And to say, oh, well, there are no hard and fast rules, it's all a question of whether it's unconscionable, which I accept a literal interpretation of what Lord Justice Hoffman said in El Ajou might make you think, it is effectively an invitation to treat the water as uncharted and to throw away any attempt to try and establish who owns what by reference to principle.
Well, first point, we're not trying to establish who owns what.
Well, all right.
That's the whole point of our argument. And the second is that these are waters you're not being asked to charter. This is not what the appeal's about. The appeal is about whether it's necessary to establish a proprietary ownership at all, in all cases, before you can get a claim in knowing receipt off the ground. There may well be any number of very complicated factual situations in which degrees of knowledge may come under consideration, where onward receipt may come under consideration, where a bona fide purchase of a value subsequently acquires knowledge, and the court has to grapple with, can it ever be conscionable? Is it unconscionable on the facts of that case? None of that's in front of you. The only question is whether or not, in all cases of knowing receipt, it is a necessary precondition that there must be equitable ownership belonging to the claimant while in the recipient's hands. That's all this case is about.
I mean, for my part, Mr. I quite accept that there's no question of the defendant in this case having been equity's darling. That's been established against it. But if one's view as to the reason why equity's darling is not adversely affected by subsequent knowledge of the breach of trust is that having been equity's darling, the beneficial title of the claimant has been overridden, then that leads to question two. Well, if some other technique has led to the overriding of the claimant's beneficial title, such as land registration, Section 2 of the Law Property Act, or foreign law, why doesn't the same conclusion follow?
As in a sense, Lord, we are probably sort of circling around the central.
And I'm not expressing a conclusion.
No.
I'm just saying that's why it seems to me to be relevant.
Well, perhaps we should allow you to develop your submission.
I'm grateful. All I was going to say, finally, by way of introduction on knowing receipt, is that, in a sense, just as we're pulling some of the threads together that have already been teased out in the course of the exchanges, is to ask you to bear in mind, as we're turning pages of case reports, that proprietary claims have been brought against people who happen to be knowing recipients. but that does not mean that the proprietary element of the recovery that is being sought is the remedy in knowing receipt. And it is, in our submission, clear from when one goes through the case law that as I say, the two key things that we would urge on you are that the remedy for knowing receipt is a personal remedy in the way that we've described, and secondly, that the constituent elements are breach of fiduciary duty, transfer, receipt, with knowledge, sufficient knowledge to render it unconscionable to retain the benefit of the receipt. And in a sense, that sort of leads to a relatively general proposition, which is essentially this. If you accept that the claim in knowing receipt is based on the elements that we have identified, 3 elements we have identified, and if you accept, as a lot of the cases say, that the claim in knowing receipt is an ancillary liability, it's a word that comes up with increasing frequency over time, that then sort of poses one the question, well, ancillary to what? And having identified the constituent elements of the claim as being a transfer and breach of fiduciary duty, and sufficient knowledge, we submit that the correct analysis is that the answer to the question ancillary to what is, it's ancillary, the remedy of knowing receipt is ancillary to the breach, the primary breach of fiduciary duty.
Do you mean the primary liability of the trustee in breach?
Yes, yes. It is not ancillary to a proprietary claim. It is ancillary to, in the sense that it is one of the consequences and one of the remedies that is made available where there has been a breach of fiduciary duty by the primary fiduciary.
Yes, it's not the primary liability of the trustee, it's the primary liability of the fiduciary.
Yes.
Hence the director's cases.
Exactly. And we submit
then why isn't that what knowing dishonest assistance is doing, is providing that ancillary liability?
Yes, it is also doing that. But
and a recipient could be a dishonest assister.
A recipient could be liable as a dishonest assister also, yes, but the difference is that obviously that to be liable in dishonest assistance, you don't have to have received anything, but you have to be an assister, not just a recipient, as the bank is in this case, and you have to be dishonest. And so dishonest assistance clearly has the 2 different elements of in a sort of mens rea and actus reus, in a sense. What we urge on you is that when you see this concept of ancillary and you're thinking, well, ancillary to what? We submit that it's ancillary to the, as I say, to the primary breach of fiduciary duty. And that has a number of consequences. And again, these are points that we'll tease out as we go through the case law. That is why, first of all, when you see the way that knowledge is described in the case law, what the courts are talking about is a sufficient element of knowledge of the breach of duty. It's not a sufficient element of notice of a prior title, which would be a relevant question in a proprietary claim. The element of knowledge is knowledge of the breach, because the liability is ancillary to that primary breach. Second consequence of the liability of the knowing recipient being ancillary to the primary breach, the second consequence is, as we will see, that the case law talks about it being unconscionable for the defendant to retain the benefit of the transfer. It doesn't talk about whether it's unconscionable for the defendant to retain the property. In fairness, some do, but we would prefer you to take the view that the cases that properly analyse talk about the unconscionability of retaining the benefit of the transfer, not of retaining the property. And obviously, again, we say that is a consequence of the fact that the ancillary liability of the knowing recipient is that it is ancillary to the primary breach of duty, not ancillary to some proprietary claim. The third point to keep an eye on in the case law is that this is also why the case law insists that a claimant in knowing receipt cases must prove that the receipt of the property by the defendant is the direct consequence of the breach of fiduciary duty. It's not enough for a claimant to prove that there has been some breach of fiduciary duty which provides, so to speak, the occasion for the transfer. There has to be a transfer which is the direct cause. Sorry, there has to be a breach of fiduciary duty, which is the direct cause of the transfer. And we see that in a couple of the cases involving allegations that companies have been run into the ground and then their business is sold by receivers or liquidators. We'll see there that the claims in knowing receipt fail because the transfer is effected by office holders in discharge of their responsibilities as insolvency practitioners. So the transfer is not a direct consequence. There may or may not have been some conspiracy to run a company into the ground, but if there is, the conspiracy has to be proved in order to get previous management liable. You can't get the transferee company in that situation liable because the transfer is not the direct consequence of the breach itself. And it's this
sequentiality always involved. It seems to me that in the most simple cases, the transfer itself will be the breach.
It almost certainly. I mean, in the most successful cases, that will be the case. Yes. I mean, whether it could ever be otherwise, I don't know. But
it's the fact that the transfer is the breach which prevents it overreaching the beneficial interest.
That it prevents it from overreaching.
Yes, because a transfer that's not in breach of trust overreaches the beneficial interest.
Overrides or
overreaches.
We are overreaching this time.
I'm trying to be a bit more precise
yes,
this time round. That is true overreaching because if the trustee has authority to sell or dispose of the trust property to a stranger, then it must overreach the beneficial interest.
Yes, quite. So
it's the very transfer itself which is the breach. You don't have to establish some causal connection.
Yes, exactly so. It is, in our submission, this combination of factors, the requirement for the primary breach, the transfer being the direct consequence, and the guilty knowledge that prompts the court's intervention by, in the language of several of the cases, imposing or constructing liability as if the recipient was a trustee. And with those constituent elements or control mechanisms, whatever you wish to call them, in place, in our submission, there is no need to bolt on a further requirement that a claimant must also prove that in equity it owns and continues to own in the recipient's hands the property that has been transferred. And we would urge you to the view that you might well consider it, indeed, incoherent to impose such a requirement in the context of a personal claim for liability, a claim for an account. Because if you think about the circumstances from the claimant's perspective, the injury is suffered by the claimant when property beneficially belonging to them before the transfer is transferred to a third party in breach of fiduciary duty. That is, in a sense, the primary injury. That injury is no less grievous if the mechanism by which the transfer is effected happens to destroy the claimant's proprietary interest. Indeed, you might say that it is more grievous as an injury to the claimant if the transfer in breach of the primary fiduciary duty does destroy the claimant's beneficial ownership.
I struggle with why the third-party recipient should be liable in that situation, on the assumption that although a wrong was done by the transferor to the owner of the property, the recipient has not assisted or participated in that wrong.
Well,
and the property they've been given is property that they've taken a clear title to. And the mere fact that, that somebody else has done a wrong in the process, why should they be held personally responsible for it?
Because of the combination of factors which have prompted equity to operate in this area, namely that there is not just a breach of fiduciary duty by the primary fiduciary, but that there is factual receipt with sufficient knowledge to make it unconscionable to retain the benefit of that receipt. If those elements are satisfied, which they are in this case subject to a legal argument, those are the constituent elements for knowing receipt. Your Lordship may not be sympathetic to the
see
concept.
that. I mean, if the cases have said that, I have to accept it, but all I'm saying is I don't personally see the moral unconscionability in that situation.
And we're going to have to look in the cases to see if there's any case in which a liability has been established in knowing receipt, where the defendant could say before he disposed of the property, it was mine, I had clear title to it.
My Lord, I think
possibly that land registration case of Mr. Justice Henderson, as he then was, where it was conceded.
Yes, Hack and Raj.
Yes.
Yeah. My Lords, if there was no previous clear authority on exactly this point, I think it would have been fairly early on in both of our written cases.
To hang your hat on a dictum of Lord Justice Hoffman, as he was in El Ajou, however well known, in an environment in which, if you like, there's never been a case in which someone who could say I've got clear title has been held liable, maybe to read more into the dictum than was intended.
My Lord, I think each side, no doubt, will accuse the other of reading more into dicta than was intended, precisely because no court has actually had to address this point directly. Things are said which may, on one view, support my case, may, on one view, support the other side's case. But it is actually, I mean, coming back to what Lord Gough said, it's one of the risks of courts expressing themselves in slightly general terms when they don't have to, in relation to issues that are not specifically for them, before them, in previous case law. So it isn't a point upon which there is clear, direct authority. But as I say, what we're trying to do in these opening few minutes is just to plant in your Lordship's minds the idea that there are separate streams of remedy available in relation to a proprietary claim where you are chasing your own property, and personal liability to account where the constituent elements are not proprietary but based on the trio that we've identified. And as I say, if one looks at it from the claimant's perspective of property being transferred, property in equity that at the moment of transfer belongs to the claimant, being transferred in breach of fiduciary duty and received in circumstances in which it is unconscionable for the recipient to retain the benefit, that, in our submission, if that is the correct description of a claim in knowing receipt, it doesn't make it more conscionable for the defendant to say, not only have I received your property knowing about the breach of fiduciary duty, but I have dealt with it by registering it in my name in a way that destroys your proprietary interest. That, in our submission, should be regarded as compounding the injury to the claimant, rather than in some way mitigating it or avoiding it. And if one looks at it from the defendant's perspective, the putative knowing recipient, they are made liable because equity operates on the conscience. They receive property which they know is coming to them as a direct consequence of a breach of fiduciary duty. There is no less a receipt of property where the defendant deals with it in a way that destroys the beneficial ownership of the claimant. And there is no less, if we can use the shorthand, there's no less guilty knowledge of the breach of fiduciary duty if the mechanism by which the transfer is effective happens to destroy the claimant's proprietary interest. There is receipt and there is knowledge of the breach of fiduciary duty.
The first of those, correct me if I'm wrong, but I understood you to be saying, well, in one situation, what the recipient has done subsequent to receipt is to destroy the proprietary base. That was, I think, your first example. Now one might say, well, nobody's going to disagree with that. We're talking about the moment of receipt.
We are, absolutely.
Which then slid into your second point, which is, well, there's no difference, but it seems to me that there might well be a very big difference between whether you are dealing with property in which the claimant is still asserting at the moment of receipt that it belongs in equity to the claimant, and the other situation where that's not the case.
Well, my Lord, the question with respect is posed as if a proprietary claim is being pursued. If one accepts that the claim in knowing receipt is a claim to render the recipient personally liable to account for what he has done with the property received, then the question whether any prior equitable ownership is destroyed at the moment of receipt or very shortly afterwards, in our submission, makes no difference to the conscience of the recipient or the fact of receipt. And if the three elements are the breach of fiduciary duty, the fact of receipt, and guilty knowledge, all of those are present. And in a sense, we would suggest a fortiori present if the mechanism adopted for the receipt happens to destroy the beneficial interest of the claimant, because there is no less a receipt in that situation, and there is no less guilty knowledge. As I say, in one sense, the guiltiness of the knowledge is worse, because the recipient knows there's been a breach of duty, knows they're receiving something for their own benefit, and is doing it in a way that factually may destroy, or does destroy, an equitable claim. And in our submission, if one looks at it from the perspective of equity operating on the conscience of the recipient, the conscience of the recipient cannot be easier simply because the mechanism that has been adopted to either effect or complete the transfer involves the destruction of a proprietary interest. And we point out in our written case, as you may recall, that if the Court of Appeal's judgment is upheld, it will produce what we submit is an arbitrary outcome, namely that the same factual circumstances in terms of a breach of fiduciary duty, factual receipt by a defendant, and guilty knowledge, the outcome in any case governed by English law in relation to a claim against a defendant amenable to the equitable jurisdiction of the court will depend not upon the fact of receipt or the guiltiness of the knowledge or the breach, whether there was or wasn't a breach of primary fiduciary duty. It will simply depend on the location of the receipt.
Oh, it's only arbitrary if you think that having a property right doesn't matter.
Well, it is arbitrary because it produces different outcomes in relation to the same constituent elements.
Well, the three constituent elements that you emphasise are the same, and the fourth one that the respondent says is also necessary isn't the same.
Indeed. The other point we make in our written case is that if that is the outcome, then it does provide an opportunity for those who are minded to commit breaches of fiduciary duty to make sure that they are received in jurisdictions that would produce the result that has occurred in this case. So,
well, why will that help them? It won't affect their own liability. That will mean there's nobody else who the claimant can go after, so it'll have to go after the defendant only.
Yes, but
well, why is that going to encourage the defendant to
when you say
look for jurisdictions like this?
When you say your lordship says the defendant,
I mean the original,
the original fiduciary,
defaulting fiduciary.
The original defaulting fiduciary may well themselves either be untraceable or not worth pursuing. They may have. There could be any number of reasons why a claim, and that is essentially why claims against claims in relation to ancillary liability are pursued. It's quite often because the primary fiduciary is themselves insolvent.
But the real point is one of motivation. If because the trustee is going to be liable anyway, it's not his motivation that leads the property to being dealt with in a friendly jurisdiction which kills off the beneficial interest, then it'll be the motivation of the recipient. And in that case, it'll be a dishonest assister.
With respect, the facts of this case illustrate exactly the reverse. Mr. Al-Sanaya is the primary fiduciary. He is heavily indebted to Samba Bank. He transfers these disputed securities in breach of his fiduciary duties to Samba Bank, who credit them against his personal liability to the bank. So he is using assets in respect to which he owes a fiduciary duty to SICL to reduce his personal liability to Samba. So it is his choice, and it's for his benefit, because he is reducing his personal liability. As I say, in our submission, it is a very clear illustration of exactly the vice, if you accept it's a vice, that would arise in allowing those who may be tempted to commit breaches of fiduciary duty to choose where to park the benefits in order to defeat any claims against those assets in a third party's hands. This case is a classic.
But he hasn't reduced his personal liability.
Well, following that through, he swapped a liability to Samba for a liability to the beneficiary.
Well, he knows he's not going to be pursued by Samba, and we know he's not worth pursuing in this jurisdiction. Otherwise, no doubt, we would have done. But of course,
but this is a sort of, interorum type of argument. And at the moment, I struggle to see why the defaulting fiduciary is going to be better off by committing a breach of fiduciary duty. However he decides to commit it.
Well, I mean, as I say, I've explained why we submit that this case does illustrate exactly that. If your lordship remains of the view that you do, then I hope you'll write him a dissenting judgment. So just to wrap up the introduction.
It's not critical to the result of the case.
Could I just take you back to assisting? I think at an earlier stage you said that you have to be an assister, not just a recipient. But I can think of many circumstances in which a recipient most certainly is an assister.
Oh, yes.
And indeed, a recipient could be shuttling money around the world and assisting in that sense.
Yes.
Or indeed, with sufficient knowledge, assisting in a whole series of other contexts.
Yes. It is entirely possible that the same factual situation could give rise to a proprietary claim and a claim in knowing assistance and a claim in, dishonest assistance and a claim in knowing receipt. Yes, they're not mutually exclusive.
Yeah.
The question is simply whether the proprietary claim is a necessary element within knowing receipt. We know it's not a necessary element in dishonest assistance. So there clearly is a form of ancillary liability that doesn't depend on any form of proprietary entitlement as against the defendant. So the question in this case is that given that that is undoubtedly the position in relation to dishonest assistance, whether it is also true against the different claim of knowing receipt, where, as I say, and one can understand in a sense the shifting balance, because where you're trying to make somebody liable who hasn't received any property, clearly a higher threshold of guiltiness, dishonesty, is required, and a higher level of participation, namely positive assistance, is required. So one can quite understand why those two thresholds are somewhat higher. In relation to knowing receipt, there is receipt, factually, and so one, in a sense, can understand the policy underlying the composition of a cause of action that has a lower threshold of guilty knowledge, merely knowledge sufficient to make it unconscionable, and in our submission, one shouldn't get confused between the mere fact of receipt with that knowledge and a proprietary claim which does depend unquestionably on being able to prove ownership in equity of the asset in the recipient's hands.
But I think the answer to the question, you are positing why in a dishonest assistance situation, is there no issue about a continuation of a proprietary interest. That's because that is a genuine accessory liability. It is a secondary liability that lines up coherently with other examples of secondary wrongs. But when we're dealing with knowing receipt, you are not participating in the wrong. It's not an accessory liability in that sense. It is certainly parasitic, or as you've described it, ancillary on a primary wrong. I accept that. But it isn't actually, there's no participation in relation to that wrong. And it's therefore, it's just, it's an articulation of a different type of wrong. Now, of course, it's open to you to say, yes, it's a different type of wrong, and you're explaining what the ingredients of that different type of wrong are. But I don't think you can slide from saying, oh, look at dishonest assistance, that doesn't require a proprietary equitable interest to survive, to saying, therefore...
No.
No, okay.
No, I'm not saying therefore.
No, okay.
But equally, it may be worth just sort of thinking about whether it is actually right to describe the position of a knowing recipient as somebody who doesn't, in any sense, participate in the breach. And they don't participate in the sense of actively causing it to happen.
No.
But they participate in the sense that they are knowingly receiving the proceeds of that breach. Without them as the recipient, that breach would not have happened in the way that it did. So participating is a slippery word in this context because it implies, well, it depends how you're using it and what you convey by it. Assistance, we understand. There is a positive act of facilitating the breach. But knowing receipt it involves guilty knowledge, and it involves, as I say, receiving something, knowing that it is the receipt, direct receipt.
Not at the time of the receipt, necessarily at all.
Well, not necessarily.
Not.
It's the coincidence of holding something with guilty knowledge that triggers the liability. I agree. You can be held liable with so to speak, after acquired guilty knowledge. That is true. But it's the coincidence.
Well, the only time-sensitive aspect of the knowledge is that it precedes your disposition or destruction of the property. It's got it's got no necessarily connection with the timing of the receipt of it.
No. Well, no, not with the timing of the receipt. No, that is true. So essentially, Lords, I think in the course of having the exchanges that we have, I think in conceptually you've got our stall set out. We say personal remedy, equitable jurisdiction, based on the three elements that we've identified. Essentially, the difference between the parties in this appeal is that we say that knowing receipt is ancillary to the primary breach of duty. It is a cause of action which involves purely personal liability, that it is fault-based, receipt-based in the sense that it is based on the fact of receipt, and as I say, that it's ancillary to the primary breach of fiduciary duty. Whereas, as my learned friend says in his case, paragraph 7, the fundamental principle is superiority of title. Could I just spend then a few minutes talking about unjust enrichment? Obviously, the parties received a message from the court saying that you would be assisted by submissions from the parties on the extent to which, if at all, the law of unjust enrichment is relevant to this case.
And your submission will be it isn't.
Our submission in short order will be that it isn't. Could I just, without being too peremptory, explain why under two headings? The first is, in a sense, the narrow focus on what this case and specifically this appeal is about. And secondly, we were just going to make some slightly more general observations about characterization under the law more generally. But just starting, one way of trying to provide the assistance that has been sought in relation to the potential relevance of unjust enrichment is simply to say that although the pleadings are not before the court, it is the case, I would have to accept, that the pleaded cause of action is not characterized as one based on unjust enrichment. The claim form doesn't mention unjust enrichment. The substantive issue on liability has been argued in the courts below solely on the basis of an equitable claim in knowing receipt.
But you could be arguing, although I think you're saying or not, that knowing receipt is based on a principle of the recipient being enriched by the transfer, and that is what makes it just to have to account for the money.
What I wanted to do, in a sense, was sort of fess up to what the pleaded cause of action is, what the issues that have been argued below, and what, in fairness, what the issue in respect to which permission to appeal has been granted, namely, as I described at the beginning, is a proprietary interest, a necessary element in knowing receipt. So in those respects, unjust enrichment isn't on the table. It would not be a complete answer to the question, though, to leave it there, because it is the case that, at least for the purpose of determining the applicable law to the claim, the Saudi National Bank's principal case was that the claim was properly characterized as being based on unjust enrichment. And they said that on there's a choice of law issue, because they wished to argue that under Article 10 of Rome II, the place of enrichment was Saudi Arabia. And so they were saying that the applicable law was Saudi law, not English law, because properly characterized it was a claim in unjust enrichment. Alternatively, they said under Article 4 of Rome II, Saudi law applied because Saudi Arabia is where the damage occurred as a result of the share registration. And their third alternative argument was that under the common law, the jurisdiction with which the obligation to restore the benefit had its closest and most real connection with Saudi Arabia. Now, in the event, those were arguments that Saudi National Bank was debarred from running for non-compliance with disclosure. So those were pleaded in the defence, they were answered in the reply, but as I say, they were issues which the trial judge decided could not fairly be tried absent the disclosure that had not been given. And so I just wanted you to be aware that those matters had been pleaded. And as my Lord Legate pointed out, it is in principle possible to characterise the claim as being one in unjust enrichment. It is a matter of legal characterisation. It's difficult to see, even if the issue had been argued, it's difficult to see what different evidence would have been adduced at trial if the claim was characterised as one based on unjust enrichment. And it might well be said that if you, irrespective of how we have characterised the claim, if you were to accept that the claim should properly be characterised as one based on unjust enrichment, then in two respects, it is quite possible that the claim would have been easier to make good. First, because in unjust enrichment, one would not be having to prove guilty knowledge. And secondly, because by virtue of the decision of this court in Foskett and McCowan, it is apparent that the survival of a claimant's beneficial interest in the property transferred is not a necessary ingredient in a claim to reverse unjust enrichment. Indeed, the fact that beneficial ownership has passed is quite often, as Lord Millett pointed out, the very basis of the claim in unjust enrichment. We'll go to Foskett and McCowan for other reasons later, but just so that you have a note of it, it's at the decision is at page 1289, and the passage I was mentioning in the speech of Lord Millett, with which Lord Brown Wilkinson and Lord Hoffman agreed, is at page 1316, D to H. So, in our submission, as I say, it may well have been easier for the claim to have been pursued on that basis. We would suggest that there could be little doubt that Samba was enriched. It took a transfer of the disputed securities. It did so in a manner which destroyed my client's beneficial ownership. So, looking at the substance of what has happened, it would, in our submission, be difficult to suggest anything other than that Samba and now Saudi National Bank have been enriched at the expense of my client. The question whether the enrichment was unjust would no doubt raise the question of whether or not any of the recognised unjust factors were present. So whereas that's concerned, your lordships, I hope, were provided with a very short supplemental bundle. I wasn't proposing to go to it because at least one member of the Constitution will be well familiar with one of the elements in it, because it's Professor Byers' restatement of the English law of unjust enrichment, which, when it was written, suggested that one of the unjust factors which had not yet been formally recognised but should be recognised was want of authority. And we've included that in the supplemental bundle at page 111. Since that was written, case law has caught up, and we have included a decision of Mr. Justice Sales, as he was in a case called Relfo and Varsani, which at paragraphs 86 and 88 has accepted that lack of authority, want of authority, is a recognised form of, it's a recognised unjust factor. Sorry, if I didn't give it, paragraphs 86 and 88 at pages 30 and 31 of that bundle. We would submit, that case did go to the Court of Appeal, and the Court of Appeal didn't interfere with that ruling at all. So we submit that there is, were it to be analysed on the basis of unjust enrichment, rather than knowing receipt, that the constituent elements would be readily made out. The question would then be whether there were any defences available, and so far as that is concerned, again, the facts that on the assumed facts, which are set out in the Statement of Facts and Issues, Samba would have been found to have sufficient knowledge. Well, it can't argue that point, and so it cannot claim would not have been able to have claimed a defence based on an innocent change of position. So, as I say, we would suggest that it clearly isn't a pleaded issue. It's not the reason we're here in front of you, but if that were how the claim were to be characterised by your lordships, that in our submission would be the outcome. That leaves hanging a rather broader question, which I approach with considerable diffidence and will do so very briefly, which simply, rather than just by looking at the pleaded issues in this case, whether the law of knowing receipt should be subsumed within unjust enrichment, which is obviously a big policy issue. I don't think it is controversial to say that the current orthodoxy is that the two causes of action are conceptually very different. They have different jurisprudential bases in the sense that one is based on the equitable jurisdiction of the court, which operates against the conscience of the recipient, whereas unjust enrichment doesn't. It is not fault-based. And there's been, for other reasons, we have the relatively recent decision in DD Growth in the bundle, which you may be familiar with. I know my Lord Briggs will recall it, where that, if I can call it orthodoxy, was articulated, and it's in, again, I don't need to go to it for present purposes, but just so you've got a note, it's paragraph 58 at page 968 in the bundle. Our attention was drawn to the materials that have been included in the authorities, including the article essay by the late Lord Nichols. Your lordships will be well familiar with that, and I don't think I can really say anything other than that. It is apparent from what he wrote that he was recognising that what he, and to use his own language, what he was proposing was a radical step for the courts. That's at page 2454. The section of his essay under the heading "The Present State of the Law" acknowledged that knowing receipt is a purely personal form of fault-based liability. That's page 2444. And his proposal was that the law should be developed, in his language, by essentially conceiving of a strict liability principle in relation to all third-party recipients, irrespective of fault, and a separate cause of action against dishonest assisters. And that, page 2453. All we can offer to you by way of submission, because, as I said, this is, we would acknowledge not what this appeal is about. All we would say is that in the years since that article was written by Lord Nichols, the radical step that he contemplates hasn't been taken, and your lordships, I imagine, will be familiar with the passage in Lord Justice Norse's judgment in Akindele, where he says, certainly in the Court of Appeal, it would have been a fruitless exercise to have any debate about that, but in any event, he begged leave to doubt whether such a development was preferable to fault-based liability. So that was Akindele in 2001, and the relevant passages are in the bundle at page 411C to E. And as I say, more recently, the decision in DD Growth, which is 2018, continues to recognise that there is a conceptual difference, and that is conceptually very different are the words used in the judgments of Lord Sumption and Briggs, with which Lord Carnwath agreed. So on the current state of the law, as I say, I don't think it's controversial to say that knowing receipt and unjust enrichment clearly are regarded as separate causes of action with very different ingredients. Whether this court is minded to take the radical step suggested by Lord Nichols, I think, is a matter entirely for your lordships, on which I can't really assist, other than, as I say, to remind you of what Lord Gough said in Westdeutsche Landesbank.
We didn't have the pleadings, perhaps for obvious reasons.
Yes.
Is it possible to send us the key pleadings so that we can just scrutinise what was said?
Yes, of course. And we will do that, and I'll just mention it's the re-amended defence. You will be looking at paragraphs 57 to 59, but we'll send you the re-amended defence, paragraphs 57 to 59, and the reply. We'll send you the particulars of claim. Simply to illustrate, they don't say unjust enrichment. We'll send you the defence because it does, and the reply because it answers that. And we'll just give you a paragraph.
So to summarise what you're saying, as I understand it, it's not before us because it wasn't pleaded. That is unjust enrichment. Had it been pleaded, you are suggesting that there might have been, it might have given your client a more straightforward route to victory, so to speak.
Yes. I don't think I can decently say more than that.
No. You're not submitting that knowing receipts should be conceptualised as involving two different underlying causes of action, one of which is an unjust enrichment claim, along Lord Nichols' proposal.
No.
Mr. Can I just check I understand what you mean by fault-based in the knowing receipt context? I mean, the candidates would appear to be the receipt, beside which I think I put a mental cross, and the dealing or lack of dealing with the property once after having knowledge of that there was a breach of trust, to which I put a sort of mental tick alongside. Have I got my ticks and crosses in the right place?
The thing that triggers equity's intervention is the coincidence of possession of property and guilty knowledge. So
I think you said in D.D. Grove that triggered a restorative duty. So just not restoring it is fault-based. And so much more must be destroying it or alienating it.
Yes.
Yes.
Yes. Yes. But the I mean, it once. Once there is guilty knowledge, there is, in principle, a liability to account. If there is guilty knowledge coinciding with possession of property, there is a liability to account. It would be conceptually slightly odd to suggest that once the guilty knowledge has been acquired, there isn't any liability, because at that point, the recipient hasn't done anything with the property since acquiring that knowledge.
So the fault is actually in taking possession.
The fault
in receiving.
There will be fault if the fact of receipt coincides with guilty knowledge.
Yes.
Absolutely.
But there's no fault prior to the acquiring of the relevant knowledge.
Sorry.
As far as I can see.
No, there isn't. No, that is, I accept that.
But as I understood the question, I may have misunderstood our Lord Briggs's question, but the fault isn't what's happened subsequent to receipt necessarily. It is the actual receipt with the guilty knowledge.
Yes.
Yeah.
So that is all we wished to say with regards to unjust enrichment. And I was then going to have a little tour d'horizon of the case law, as I say, in chronological order, pausing over some more than others. The starting point, the first two in the early days, one doesn't learn a great deal because there isn't a great deal of detailed analysis. But what we will say is that if it is being suggested that the claim in knowing receipt is dependent upon establishing a continuing proprietary right on the part of the claimant. That element is surprisingly absent from the earliest articulations of how liability arises. So what we just wanted to do very quickly, to start, unsurprisingly, with Barnes and Addy, 1874, which is at page 737, or if people want the hard copy, it's tab 24. And the facts don't particularly matter. A trustee, a will trust, had split the fund and appointed a sole trustee of one half of the fund, who then dissipated the trust fund, and an attempt was made to render solicitors liable who had drafted the documentation that gave effect to those arrangements. Lord Selborne, at page 744, five lines from the end of 744, he talks about different levels of responsibility, and then he says, but on the other hand, strangers are not to be made constructive trustees merely because they act as the agents of trustees in transactions within their legal powers, transactions perhaps of which a court of equity may disapprove, unless those agents receive and become chargeable with some part of the trust property, or unless they assist with knowledge in a dishonest and fraudulent design on the part of the trustees. So there one gets the earliest articulation of the two elements that have now become known as knowing receipt and dishonest assistance. Didn't become dishonest assistance for some time yet, but that's the origin. And as I say, what one does not get is a statement there that the predicate for knowing assistance is a continuing beneficial ownership. It is written in terms that may have assumed that the trust property would, in a sense, remain trust property in the hands of a recipient. But it certainly does not stand as authority that that is a necessary element. And it is important, as I say, in all these cases to look at what was in fact being decided. The second case we just want to look at...
Just before you go past that, Lord Selborne obviously didn't think he was making new law, and he talks about maintaining the doctrine which is established in this court. Thus far, attempts at my end to see where he got it from have fallen on rather parched ground.
Well, Your Lordship's not alone. I think it may have been one of those deep sea forms of life that hadn't surfaced in the reports.
Counsel weren't called on, and there's no list of authorities.
Mr. Lindley, who might have given some assistance,
yes.
Perhaps it was in his written case.
I think if Your Lordships treat Barnes and Addy as the first reported articulation of these principles, you wouldn't be alone, because it is generally regarded as the starting point in the reports.
Yeah.
Read Diplock in the Court of Appeal, case with which you're probably familiar, the distribution of funds from an estate to various charities, which turned out to have been invalid bequests and were then sought to be recovered. And the claim is brought with both what we would now regard as being a knowing receipt head and separately with a proprietary head. And one sees that at the top of page 988. You'll just see at the top of 988 it says, as already indicated, the appellant's claims in personam must be subdivided and fall under two quite distinct heads. First, it's argued that by the terms of the letters which accompanied all the executors' payments, the respondents were given notice of the invalidity of the trusts declared of the testator's residuary estate, or at least were put upon inquiry as regards their validity, so that the respondents who were in any event pure volunteers, were subjected to a constructive trust of the monies they received in favour of the next of kin. So that, we apprehend, is what we would now call a knowing receipt claim. And then secondly, it is argued that apart from any notice which the respondents may have had of the true effect of the testator's will, they had in truth no right to receive any of the monies paid to them, and that in the circumstances of the case already set forth, the unpaid next of kin have a direct claim, recognised and established by the courts of equity, to recover from the respondents the sums improperly paid to the respondents and properly belonging to the next of kin. So that, we apprehend, would be regarded as a proprietary claim. And if we just turn over to see how the first of those, what we would call knowing receipt, is dealt with, we turn over to page 989, and you'll see about a third of the way down the page, just after the reference to Chichester Diocesan Fund, the court says this: but we have come to the conclusion this branch of the appellant's claim ought not to succeed, as we have already stated each of the respondents, in fact, accepted that the monies paid to them in good faith and in the belief they were properly entitled to receive what the executors handed to them. And without reading the whole page, if we just pick it up again about a third of the way before the end, so two-thirds of the way down the page, there's a line beginning with the words "results in invalidity," and it's the next sentence: in our judgment, persons in the position of the respondents themselves, unversed in the law, are entitled in such circumstances as existed in the present case to assume that the executors are properly administering their estate, and if, as is admitted in this case, they took the money bona fide believing themselves to be entitled to it, they should not have imposed upon them the heavy obligations of trusteeship. So it would appear that what was decided is that there was, to use my shorthand, no guilty knowledge in the receipt. No consideration was given in the course of this judgment to the question whether or not there was still a proprietary basis to support that claim, the knowing receipt claim. It is simply absent from the court's analysis. So whilst entirely accepting that that in one sense is a slender basis upon which to rely upon it, it is striking that the first two cases we've identified, which appear to address the question of knowing receipt, do not treat a continuing proprietary right on the part of the claimant as a precondition to success in the claim.
There was no question in that case of any overreaching or overriding, because these were all volunteers, weren't they?
Yes, indeed.
Yeah.
Yes, no, that's absolutely right.
I mean, it is actually. I realise you've conceptualised the personal claim as one for knowing receipt. Is it anywhere made absolutely clear that there was any degree of knowledge on behalf of the charities? Is it not often conceptualised as a rare case of strict liability, personal strict liability?
The claim that succeeded is, yes. But that is because on the findings of fact, the court rejected the submission at the top of 988, which I read, which was the submission that the respondents were given notice of the invalidity of the trusts declared of the testator's residuary estate, or at least put on upon inquiry as to their validity, so that the respondents were subjected to a constructive trust. So the argument in support of knowing receipt was based on the fact of receipt and a supposed sufficient degree of knowledge that the payment to the volunteer was a breach of the executor's trusts.
But what I'm suggesting to you is, was the knowledge ultimately of any relevance to the liability?
No. To the claim that succeeded, no, it wasn't.
The proprietary claim succeeded.
No, in the personal claim. My understanding would be, but I stand to be corrected, that this is a rare example of not a claim in knowing receipt, but a personal liability,
Yes.
based on strict liability, subject to certain sort of rules, and always conceptualised as something peculiar to do with wills and so on and so forth.
I think that's
stands
right.
slightly outside knowing receipt.
Well, the claim that succeeded stands outside knowing receipt. The claim we've just looked at, which was dismissed, was pleaded in knowing receipt. That's
Right. Sorry, I see your point. Okay. Yeah. But right. I don't know what you then say. What do you say about the claim that succeeded?
Nothing, because it isn't something that assists you in relation to the issue before the court.
Because it's not.
Because it's not
conceptualised as knowing receipt.
Exactly.
Thank you. Yeah.
Sorry.
That's
I'm sorry. No, I'm sorry if I didn't make that clear.
Entirely my fault.
We can move forward 20. No, we can't. We can. Yes, we can. 20 years. 1968. We're up to Salanga, Rubber and Craddock, which is 1968, and it's at page 1837. And significantly, this was a case involving. We've got two of them. This and Belmont Finance. Two cases, both involving misuse of company funds to buy shares in themselves. So, just in terms of context, not a formal trust structure, but a corporate situation where directors are accused of acting in breach of their fiduciary duties. We cite this simply for, and if we could look at page 1860. You'll see at the very bottom of page 1860 there's a heading, the stranger's liability as constructive trustee. I won't read the whole of that paragraph, but I would certainly commend to the court what is said down to, at least over the page, at 1861D, where the judge, Mr. Justice Angode Thomas, identifies different usages of the so-called constructive trustee, and it's the number 2, letter C, in the margin with which we are concerned. Yeah. Those whom a court of equity will treat as trustees by reason of their action of which complaint is made. Distinguishing features are that trustees claim to act in their own right and not for beneficiaries, and no trusteeship arises before but only by reason of the action complained of. Now, again, it's expressed as a high-ish level of generality, but we draw it to your attention partly because it illustrates the different usages of constructive trust that I mentioned, but partly also because it describes the ancillary liability with which we are concerned without reference to any requirement for a continuing proprietary right on the part of the claimant. It refers to the liability being triggered by reason of the action of the recipient, only by reason of the action complained of.
So the action gives rise to a circumstance where they're treated as if they were a trustee.
Exactly so. And that is all part and parcel of the picture we are trying to build up for you, that they are not trustees. And one of the reasons why they don't have to be trustees is that they're not holding property on trust. It doesn't have to belong in equity to the claimant. Equity operates against the conscience because of what they've done, not by reference to vindicating a proprietary right in the beneficial owner. And if we then just look...
Do you make the point that in this case there never was any property held on trust?
I do if it's in our favour, yes. I have to remind myself of the facts as to why...
Well, I'm assuming that to be the case because it was the company's just simply the company's property was.
Oh, I see. Yes, indeed. Yes, indeed. So sorry. Yes,
Directors are fiduciaries. They're not.
Yes. No,
they're not
exactly
trustees.
so. Exactly. Sorry. Yes.
And if they use the company's property improperly, the company retains no equitable interest.
Exactly so.
So why isn't that a major point for you in lots of these cases?
Well, it is, my lord. That's why one of the very first points I put to you was that when I was going through the different usages of constructive trust and pointed out that it is, in relation to knowing receipt, it is a term that is used where there are no trusts and where the property that is being diverted is either company property or Crown property.
Yes, thank you.
Just very quickly then, page 1864. Right at the top of 1864, it seems to me imperative to grasp and keep constantly in mind that the second category of constructive trusteeship, which is the only category with which we are concerned, is nothing more than a formula for equitable relief. The Court of Equity says that the defendant shall be liable in equity as though he were a trustee. He is made liable in equity as trustee by the imposition or construction of the Court of Equity. This is done because, in accordance with equitable principles applied by the Court of Equity, it is inequitable.
Equitable, I think.
It is equitable that he should be held liable as though he were a trustee. Trusteeship and constructive trusteeship are equitable conceptions. So again, it's quite clear from what the judge is saying is that what he's talking about, what we are describing as the paradigm knowing receipt case, is not a vindication of equitable ownership, of beneficial ownership. It is an expression of equitable relief based upon an imposition or construction of the court. So, and that in our submission is important language, and it recurs in other cases. If what was happening was a recognition of an existing beneficial ownership, that language wouldn't have been used.
Well, in any company case where the complaint is a breach of fiduciary duty by someone who isn't a trustee, then the constructive trusteeship has to be imposed as equitable relief.
Indeed.
Because there is no pre-existing trust.
Exactly so, my lord.
When I say you haven't made a big point of this, I suppose what I'm saying is that in your written submission, the only reference I could find to it, but correct me if I'm wrong, was in a footnote 4. In other words, you didn't seem to be making anything of the distinction between whether you've got a true trust at the start,
yes,
and the very many cases of which you said they're company properties and Crown properties, where there plainly isn't a trust at the start, and therefore you might be said in your favour, it's hard to see how one's talking about the continuation of an equitable proprietary interest.
Well, it would be tedious if oral submissions did nothing other than replicate what was written. The point is there, it may be sounding louder in your lordship's ears than we put it on the page. But
it does take you to Mr. Justice Angoy Thomas's own attempt to deal with that problem, which starts, doesn't it, at 1857? I mean, all under the context that this is, I think, a dishonest assistance case and not a knowing receipt case in the end. But I mean, that's by the way, because he's looking at these liabilities compendiously.
Yeah.
It's where he starts just below letter A.
Sorry, which page, my lord?
1857.
Right. Yeah.
And there he does try, with what degree of success we can all agree or disagree, but to see how it is that in the corporate context the Barnes and Addy type of liability can arise. Yes. And he goes through quite a lot of cases, including in particular Russell and the Wakefield Waterworks.
Yep.
And lands allotment and so on.
Yep.
All really to explain why, although there isn't a traditional trust structure in place, nonetheless the traditional trust structure principles, including dishonest assistance and knowing receipt, can be transferred to the corporate context.
And what we submit that you get from that is that the common thread is a fiduciary duty owed in relation to the stewardship of property. And if there is a breach of that fiduciary duty, it doesn't matter whether the fiduciary himself was the legal owner in a trust structure or a director of a company which owned the property. What the thread that runs through consistently is a breach of fiduciary duty, not a transfer of trust property as such. It's a transfer in breach of fiduciary duty, and that is why it is so important that the guilty knowledge is repeatedly referred to as sufficient knowledge of the breach of fiduciary duty, not sufficient notice of the ownership, the beneficial ownership of the property. Very briefly, Carl Zeiss against Herbert Smith. So that's at page 804. This was the aspect, as I'm sure you know, the context was the dispute between East and West German incarnations of Carl Zeiss. Herbert Smith, acting for the West Germans, faced a claim by the East German Foundation that they were receiving, by way of payments on account of costs, money that belonged in equity to Carl Zeiss East Germany. And the court had to grapple with the claim there. And the reason we just wanted to draw to your attention what is said at pages 8 to 8 really from letter F, G, across to the next page. I don't propose to read it to you, but what Lord Justice Edmund Davis articulates in our submission is a clear expression of the concept that what is happening in this kind of case is an equitable response to a want of probity. It is not equity's response to a transfer of a beneficial ownership. He repeatedly uses the word, and you'll see it in the very last line of 828, what I would call want of probity. And it's that element that ultimately becomes expressed when we get to Akindele as sufficient knowledge of the primary breach of fiduciary duty. And so we submit that what you get from this case, and the reason why Herbert Smith were not found liable, is that the foundation of the liability, properly understood, is not an equitable vindication of a beneficial ownership right, but an equitable enforcement against the conscience of a recipient, where there is a sufficient want of probity.
The second sentence in that paragraph is quite interesting. Speaking as an outsider looking in on the law of equity, its boundaries have perhaps been left perhaps deliberately vague so as not to restrict the court by technicalities in deciding what the justice of a particular cause may demand.
Indeed so. Well, I'm grateful for that, and that's the sort of answer one might have given if one had thought of it when Lord Leggett suggested to me that I was suggesting an entirely unprincipled approach. But it is an illustration of the need to avoid being over-prescriptive. And one sees that coming up again in other cases. Trying to just move through as quickly as we can. Belmont Finance is next. We've moved as far as 1980, and that is the report starts at page 750. This is another misuse of corporate funds to buy shares in the company itself using its own money, so obviously it's another case not involving a trust as such. The claim was brought in conspiracy, dishonest assistance, and knowing receipt. The claim in knowing receipt succeeded, we would submit, on the basis of the fact of receipt and guilty knowledge without reference to any requirement for a continuing proprietary base. One gets that perhaps most clearly if I just go to one sentence in Lord Justice Gough's judgment, as he was at page 767. And it's the passage between H and J towards the bottom of the page, paragraph beginning what Belmont has to show. What Belmont has to show is that the payment of the £500,000 was a misfeasance, which for this purpose is equivalent to breach of trust, that City received all or part of this money, and that it did so knowing, or in circumstances in which it ought to know, that it was a breach of trust. There is no reference there, or in any of the other judgments, to a requirement that the claimant, the plaintiffs, also had to prove continuing beneficial ownership of the £500,000 in the recipient's hands.
And the qualification of ought to know.
Yes, well, the quality of knowledge is something that gets analysed and refined and reaches its apotheosis in Akindele. But at this stage, on the degree of knowledge, so to speak, the courts were still finding their feet.
But I mean, perhaps closer to the issue is what Lord Justice Buckley says at 762, isn't it? Where he recites the Barnes and Addy twin bases of liability.
Yeah.
And then says, as you would expect him to say as a preeminent company lawyer, a limited company is not, of course, a trustee of its own funds. And he then goes on to explain why, nonetheless, the Barnes and Addy principle applies. And he seems to do so on the basis that the fund should be treated as a notional trust fund because of the director's fiduciary control of the company's property.
Yes. And then he says at between F and G, in the present case, the payment of the £500,000 from Belmont to Mr. Grosskirth, being an unlawful contravention of the restriction against use of company funds for the acquisition of their own shares, was a misapplication of Belmont's money and was in breach of the duties of the directors of Belmont. 489,000 of the 500, as so misapplied, found their way into the hands of City. With City's knowledge of the whole circumstances of the transaction, it must follow, in my opinion, that City is accountable. So again, he reaches his ratio. The outcome is reached by reference to the fact of receipt and the guilty knowledge.
But treating the money as a trust fund. I mean, that's what he gets out of Russell and Wakefield Waterworks.
Well, with respect, I think that what he gets out of those is that the payment is made by somebody who owes fiduciary duties in relation to the stewardship of the money. He certainly doesn't say, and nor does Lord Justice Gough and nor does Lord Justice Waller, that there is any requirement that there should be a continuing, undestroyed proprietary base.
Yes, I mean, Russell and Wakefield is not authority for the proposition that the company is a Seneca trust.
No, indeed. No.
It is simply that the fiduciary is treated as having obligations, as if it were a trustee.
Exactly so. Yeah. Fiduciary obligations in relation to the stewardship of property, yes.
Yes.
Moving on from 1980 to 1987, we come to Montagu's settled trusts, which is at page 498. This was a case where the question arose as to whether the Duke of Manchester was liable to account in relation to various chattels which had been released to him, as it turned out, in breach of trust and disposed of by him during his lifetime. And the Vice-Chancellor, Sir McGarry, if you can pick up what he says at page 510, he identifies the issue at letter B. That brings me to the essential question for decision. The core question, and I put it very broadly, is what suffices to constitute a recipient of trust property a constructive trustee of it? I can leave on one side the equitable doctrine of tracing. If the recipient of trust property still has the property or its traceable proceeds in his possession, he is liable to restore it unless he is a purchaser without notice. But liability as a constructive trustee is wider and does not depend upon the recipient still having the property or its traceable proceeds. Does it suffice if the recipient had notice that the property he was receiving was trust property, or must he have not merely notice of this, but knowledge or cognizance, as it has been put? And then if we just move down to G on that page, having talked about the Baden case, he says, put shortly, under the first of these heads, a person becomes liable as a constructive trustee if he knowingly assists in some fraudulent design on the part of the trustee. Under the second head, a person also becomes liable as a constructive trustee if he either receives trust property with knowledge that the transfer is a breach of trust, or else deals with the property in a manner inconsistent with the trust after acquiring knowledge of the trust. Now, again, if you read that, assuming that he meant that the property had to remain trust property in the sense of being beneficially owned by the claimant, you will see that in those words. If you read it with the mindset that we are urging on you, all he is saying is that what is required is the fact of transfer to a recipient of property which, at the moment of transfer, is trust property. Whatever else he does not articulate a precondition that there still has to be equitable ownership in relation to the transferred property in the hands of the recipient.
And of course, in that case, he didn't have to, did he? Because these were volunteers again.
Yes, I think that's right.
So there's no question of the beneficial interest having been overreached or overridden.
No, I think that is right, yes,
Yeah.
yes. And then if we just turn over quickly to 511, towards the bottom of the page between F and G, where Sir Robert said, it seems to me that one must be very careful about applying to constructive trusts either the accepted concepts of notice or any analogy to them. In determining whether a constructive trust has been created, the fundamental question is whether the conscience of the recipient is bound in such a way as to justify equity in imposing a trust on him. The rules concerning a purchaser without notice seem to me to provide little guidance on this and to be liable to be misleading. Now, obviously, Sir Robert chose his words carefully in all his judgments, but it is in our submission clear he uses the definite article, the fundamental question. Not whether the property is still owned by the claimant. The question is whether the conscience of the recipient is bound. And that, in our submission, is the triggering criterion, so to speak, along with a primary breach of duty and the fact of receipt. And he goes on to make, in our submission, this point clear on the next page, 512, letter B. Third, there seems to me to be a fundamental difference between the questions that arise in respect of the doctrine of a purchaser without notice and constructive trusts. As I said in my previous judgment, he had given an earlier judgment in the same case, oddly. The former is concerned, purchaser without notice. The former is concerned with the question whether a person takes property subject to or free from some equity. The latter is concerned with whether or not a person is to have imposed upon him the personal burdens and obligations of trusteeship. I do not see why one of the touchstones for determining the burdens on property should be the same as that for deciding whether to impose a personal obligation on a man. The cold calculus of constructive and imputed notice does not seem to me to be an appropriate instrument for deciding whether a man's conscience is sufficiently affected for it to be right to bind him by the obligations of a constructive trustee. Then adopts more gender-neutral wording on reflection, but doesn't alter the substance of what he said. And in our submission, that is critical to the correct understanding of the difference between a proprietary claim and personal liability. And then again, it's re-emphasised at the bottom of that page, at letter H, last 4 lines of the page. Accordingly, although I readily approach the 5 categories of knowledge set out in the Baden case as useful guides, I regard them primarily as aids in determining whether or not the Duke's conscience was affected in such a way as to require him to hold any or all of the chattels that he received on a constructive trust. That is the fundamental question. It's not whether the chattels were still trust property, it's whether the conscience of the recipient is affected. And if I could just finally, at page 518.
Yes, that might be described, as we were referring earlier to Carl Zeiss, as a deliberately vague formulation.
Yes, which we would submit as a virtue. Page 518, letter H, right at the end of a line, the fact. So one of the arguments was that the Duke in question had actually seen the settlement at an earlier stage, but had perhaps understandably forgotten about it, or perhaps not recognised its significance. And what the Vice-Chancellor said was the fact that he had a copy of the 1923 settlement and could have read Clause 14b and questioned the solicitor about it does not, in my judgment, show that the Duke at any relevant time had anything that can be called knowledge that the transfer of the chattels to him was a breach of trust or in any way improper. And then he gives, between B and E, some numbered propositions. The equitable doctrine, number 1, the equitable doctrine of tracing and the imposition of a constructive trust by reason of the knowing receipt of trust property are governed by different rules and must be kept distinct. Tracing is primarily a means of determining the rights to property, whereas the imposition of a constructive trust creates personal obligations that go beyond mere property rights. And in our submission, it is clear from the way that is expressed. So they say that personal liability is being recognised there, not as a proprietary claim plus something, but as something entirely different, because it is based on knowing receipt and the conscience of the recipient.
And that's his summary too, point 2.
Yes, I was going to exactly say, and the fact that knowledge is required, and avoid the word notice. Notice in our submission is the language of priorities of title. Knowledge is the language of equity when talking about probity. And in our submission, it is significant the court again uses this concept. Now, man keeps using the expression constructive trust almost without thinking, but it is a construct. It's not a trust because it isn't dependent upon the continued existence of a beneficial ownership in the recipient's hands. It's a liability that is imposed. An imposition. He talks about in number 1, the imposition of a constructive trust. It is not the vindication of a pre-existing proprietary right, it's the imposition of a constructive trust without a requirement, as I say, for a continuing proprietary base. Adjunct Africa, we can move on to 1990, page 661. This was a case in which a plaintiff had been defrauded by dishonest employees doctoring payment orders, which resulted in money being paid to a third-party recipient, is referred to in the head note as B Limited, which then parted with the money and then went into liquidation. So the plaintiff sued the directors and I think also the shareholders of B Limited, because B Limited was not a worthwhile target, first for money had and received, and alternatively in what was called constructive trust. But that it would appear, and we can look at this in a moment, that what was being alleged was in the alternative knowing receipt or dishonest assistance, and one gets that from 687. Actually, sorry, can we just possibly just start at 678? Yeah, we'll make it straight. Where we see, just to give you the structure of the judgment, so this is Mr. Justice Millett, and you'll see it's 678, just above letter G, there's the heading to the claim at common law, and he deals with the claim there of money hadn't received. And then if we go on to page 685, just as I say, to show you the structure of what's being addressed, we have at the bottom of 685 the claim in equity, heading 3, the claim in equity. And then over the page at 686, at letter G, there's a subheading, the tracing remedy. The tracing claim in equity gives rise to a proprietary remedy, which depends on the continued existence of the trust property in the hands of the defendant. Then, over the page, we have knowing receipt, separate heading. And he refers to Baden and the two different usages of the concept of knowing receipt, of constructive trustee. And if we just pick it up at 687 letter F, the first, so talking about the knowing receipt as we understand it, is concerned with the person who receives for his own benefit trust property transferred to him in breach of trust. He's liable as a constructive trustee if he received it with notice, actual or constructive, that it was trust property and that the transfer to him was a breach of trust. Now, again, he's not specifically having to address his mind to the question as to whether or not there has to be an undestroyed proprietary base. But the one thing one can say is that he uses the past tense, it was trust property, not that it remains in the hands of the recipient trust property. If it was an essential element of knowing receipt, that there must be an undestroyed proprietary base in all cases to establish personal liability, what we do say is that that is a very odd way of expressing that requirement. And if we just go over the page...
It's interesting that he uses the word notice.
Yeah, I know.
This is after...
I know.
This is after...
Montague.
Montague.
Yeah, absolutely. Well, the one thing that we will also notice...
He also uses constructive as well.
Yes.
Which is wrong.
Yeah. And it's odd, because Montague is, in fact, it was cited in an argument and is mentioned in the judgment. Yes, it is surprising. But if we just, for what worth, go over to 688, third line. In either class of case, it is immaterial whether the breach of trust was fraudulent or not. The essential feature, the first and the second class the first is knowledge at the moment of receipt, and the second is a person who receives trust property lawfully, just at the bottom of 687, and not for his own benefit, but who then misappropriates it or otherwise deals with it. But he then goes back, so that in either class of case, it is immaterial whether the breach of trust was fraudulent or not. The essential feature of the first class is that the recipient must have received the property for his own use and benefit. So what's called a ministerial receipt, I think, in some cases doesn't count if one is simply a bank holding a bank account. This is why neither the paying nor the collecting bank can normally be brought within it. In paying or collecting money for a customer, the bank acts only as his agent. It is otherwise, however, if the collecting bank uses the money, as happened in this case, to reduce or discharge the customer's overdraft. In so doing, it receives the money for its own benefit. That is not a technical or fanciful requirement, it is essential. If receipt-based liability is to be properly confined to the cases where the receipt is relevant to the loss. And again, in our submission, it is significant that in describing, he's not having to address the issue, so neither side can really squeeze too much out of this kind of thing. But the fact is, it is in our submission significant that he is describing the relevant elements as being receipt, not continued beneficial ownership on the part of the claimant of property in the defendant's hands. It's the fact of receipt, and it's the guilty knowledge. And then, if one just also blinks briefly at knowing assistance, wasn't there yet?
Just before we leave those passages on knowing receipt, do you make anything of this point about having to receive beneficially? That is not as an agent.
It's difficult to suggest that has any real legs, so to speak. What it does is to eliminate the kind of situation that the judge mentions at the top here, mere receipt into a bank account in credit. I would love to embrace, and I hope if there's a gift horse in court, I'm not inspecting its teeth too carefully, but it is difficult to suggest that the reference to beneficial receipt means anything other than I think it's been called non-ministerial receipt. But since your Lordship has asked the question, we will give that further thought.
Yeah, what's just going through my mind is if it's been put against you that you need a continuing proprietary interest, why would there be any relevance in whether there's beneficial receipt or not?
Yeah.
I suppose what I'm trying to say is, wouldn't an agent equally be subject to knowing receipt?
Yes. I absolutely see the force of that, and we'll give it some thought and come back, probably embrace it more enthusiastically.
I'm not certain as to why benefit is a necessary characteristic, because if you receive and you have knowledge, why does it matter whether it's for your benefit or not? You have an obligation to restore.
Yes.
And so I'm not. This is the first case where this concept of for its own benefit has come into play.
It is, but it is a consistent theme hereafter. And yes, we'll certainly give that some further thought.
This is the same problem that Lord Selborne was dealing with in Barnes and Addy, of stopping the sort of inexorable logic of the equitable remedy, making banking impossible.
Yes, that might well be right. Yeah. Could I just briefly...
just take that up. Would it make banking impossible? Because the bank would then say, well, we don't know who owns this money, and leave it to the two people to squabble it out between them.
Yes. And if they were too cavalier, they might find themselves facing a quist close. Sorry, just knowing assistance very briefly between the E and F. which is obviously dealt with separately. A stranger to the trust will also be liable to account as a constructive trustee if he knowingly assists in the furtherance of a fraudulent and dishonest breach of trust. It is not necessary that the party sought to be made liable as a constructive trustee should have received any part of the trust property, but the breach of trust must have been fraudulent. That is trite law. The only reason I draw that to your attention is that in a subsequent judgment, Lord Millett appears to forget that. It is one of the illustrations that when we get to that relevant passage, I just wanted to draw.
In fact, we've moved on a little bit from that, haven't we? Because it's now recognised that it's the assistance which must be dishonest, rather than necessarily the breach of trust.
Oh, absolutely. That is now recognised to be the case. But the thing he clearly states there, which with respect he appears to forget in a later case, is that in knowing assistance, it's not necessary to have any receipt of property at all.
Yeah, sure.
We'll get to that shortly. I was going to turn next to El Ajou, but I'm conscious of the time, so I don't know if this would be a convenient moment.
If this would be a convenient moment, Mr. Crowe, then the court will adjourn. Thank you very much.